Okay, so I'm an industry analyst and I'm also a university lecturer. I'm not a lawyer, but I do drive a car. Now, anyone who drives a car needs to know about the law. You don't have to be a lawyer. But it's interesting to me that in the area of IT, that many of the people that run IT systems don't really have a thorough understanding of the law that surrounds them. So I'm going to give you a view of the upcoming GDPR from the perspective of an IT security person. And it's interesting just to sort of put this into context that when I give my lectures on information security to my final year degree students, I always start with a lecture on the law in the UK around this. Many of them turn up hoping to learn how to hack. What I actually do is start off by telling them what hacking is, defined to be, and how long they can spend in jail if in fact they engage in it. So here we are talking about the law. So it's important to understand the background to this, because in some parts of the world we have legislation that guarantees freedom of expression, but whatever is privacy and where does it come from? So in this context, the background to this is what happened in the first half of the 20th century, where we had a number of states, governments, that used information about individuals in a very repressive way in order to implement their sort of political ends. And in the late 1940s, early 1950s, there was this thing called the European Convention on Human Rights. And the background to this was basically, we never want this to happen again. And the enemy, in this case, the enemy of the individual was seen as the government. And this legislation came forward in the context of a technology where the majority of information was held on pieces of paper in filing cabinets, and punched cards and paper tape were kind of the cutting edge of how you might store data. Now, as time went on and technology advanced, the need for a level playing field in terms of the ability to transfer data and to process data in different places led to this, the OECD guidelines on privacy. And in fact, most of the European legislation comes from those principles. And that led in 1994 to the EU Privacy Directive. And in that particular point in time, the EU was trying to bring itself together into a single market. And the purpose of this legislation at that point was to have the ability to transfer data between the different states without there being any particular constraints. Now, the problem was that was a directive, and those of you that understand the arcane subtleties of the EU, a directive is not a law. A directive is a directive from the EU Parliament to all of the individual nations saying, will you please put into law, in your own local law, laws that, if you will, match what is set out in this directive. And that led to a range of implementations. It said companies like Germany were particularly rigorous in their implementation of this, whereas perhaps looking at the UK, we were less rigorous. And so there was not actually a standard level playing field. And that is played out today in the fact that many German organizations are extremely reluctant to let any of their data, personal personally identifiable data outside of Germany. You know, Amsterdam for a data center is just not good enough as far as they're concerned. Now, this then led to the need to have a way of really having a common way of treating personal data across the whole of Europe. Now, there were other factors in this, not the least of which was that the original directive was not particularly strong in terms of being able to control the data processes that lived outside of the EU. And and not only that, but that the people that put the GDPR together had gone back to the roots of this, which were not to do with simply being able to have a level playing field in a single market, but rather were concerned with going back to ensuring the privacy of the individual. And to do that in a context where the enemy is no longer seen to simply be the government, but in fact is also seen to be the large organizations that can harvest your data and use it in all kinds of different ways that you'd never imagined in response for you ticking a box. So, although there are a lot of concerns amongst organizations about what the impact of this might be, some of the benefits are that in fact it does level the playing field in the sense that wherever you are in the world, you're no longer going to be able to get away with mistreating data, that you as an organization have an opportunity to get a grip on the data that you hold. One critical thing is the fact that it helps to clarify the issues around consent, where you know, previously you would have this single tick box which allowed people to make you agree to using virtually anything for your data. And obviously, the more that your customers trust the way you process their data, the better the relationship you're going to have. So, if we look at some of the details that are around this, and it's interesting when we think about the details because we won't really know what GDPR really means until we have the first prosecutions. That at the moment I've been to an endless set of lectures, mainly given by law firms who want to sell their services as advisors to you, threatening you with all the dire consequences of what may or may not happen, depending upon whether or not you comply. But what does compliance mean? And so the working parties are still producing clarifications, but ultimately it will be when there is the first fist fight in the courts. And at that point, some of the details of what really is reasonable and what is unreasonable will only become clear. So the key point about this is that it will apply to all member states in a year from now, and the regulation means it is the same for all of these states, and it is also going to apply to data processors whether or not they are inside the EU or outside, if they are holding data about people who are resident. So, just to remind ourselves of the principles that lie behind this, data must be processed fairly and lawfully, and the fairly and lawfully is an interesting concept that we will go into. It must be collected for specified, explicit and legitimate purposes. It must be adequate, relevant, but the minimum necessary, and it must be accurate and kept up to date. None of this it seems objectionable, does it? It should be kept for no longer than is necessary, and it should be processed under the responsibility and liability of the controller, and who shall ensure and demonstrate the compliance with the provisions of this regulation. Now, there's a whole series of stories that you can tell behind this. And one of the good things about the GDPR is that it makes the processor and the controller jointly liable. Now, to give you an example of why that matters, there was a case in England where a hospital had some old computers that they wanted to get rid of, and they paid a contractor to destroy the computers because they knew they contained personally identifiable health information. The contractor was busy, and so he employed a subcontractor to actually destroy the disks. And the subcontractor looked at these disks and thought, those are working disks, I could sell them on the internet, which is what he promptly did. And of course, who buys old disks on the internet? It was a data recovery firm. And the data recovery firm looked at what was on these disks to kind of practice what they do and found all this health information. So they reported this to the Information Commissioner, who promptly fined the hospital £350,000. Now that's because the hospital was the data controller, and the hospital, under the current legislation, in fact, remained liable. And it was not the data processor, i.e. the subcontractor, who bore any liability. And everything then depended whether or not the hospital could get some recompense through the contracts that they had had with the various parties in this. So there are a lot of reasons for why some of these things are going to be important, but nothing on there looks objectionable. And so if you look at what the differences are, and I'm comparing this with the UK, because I can't compare it with Europe, all I can do is compare it with individual countries. And if you look, there is a more specific definition of what personal data is. And it's interesting that you start to see that whereas in the UK it wasn't absolutely clear that, for example, an IP address was going to be personal data, online identifiers and location data increasingly is going to be under this new legislation. And for those of you worrying about this, think about IPv6, because IPv6 means that basically your IPv6 IP address is very closely related to the MAC address, which is very closely related to the device that you have, and so you can trace through that sequence of things exactly who someone would be from an IP address. If you then look at the different kinds of data, there's personal data and there's personal sensitive data. And interestingly, these things seem to be very similar under the legislation. Sensitive data is those things that are particularly sensitive, like, for example, your sexual preferences, whether you've got a criminal record, and anything specifically to do with your health. And it's important to look at those distinctions, because those distinctions determine whether or not you're going to have to do some things under the law. Now, I'm not sure whether that's me, but whatever it is, so lawful processing is either occurs because you have had consent, and consent is one of the interesting issues, or it's necessary for the performance of a contract or compliance with a legal obligation. And these are interesting things because, for example, if I order something from you online, you obviously need to have my name and address in order to deliver what it is that I have ordered. But under the performance of that contract, you only need to keep my name and address for long enough for you to be able to deliver the stuff and to deal with any complaints that I might have subsequent to my receiving the order. It doesn't give you the right to hold this forever and a day. And there are other obvious things which are related to, for example, protecting the vital interests of the data subject. So if you are in a healthcare situation, or you have other kinds of roles like that, so you, for example, you're a lawyer or whatever, then there may be reasons why you should keep this information for a longer period and process it. And there is a special thing at the end, a special clause at the end, which allows the processing of data for historical research and so forth. Now, one of the big areas that people are confused about is whether you need to have data processing impact assessments. And it basically says that the processing where there is a specific risk. So clearly that means that if you're looking at sensitive data, the bias is towards having to do a DPIA. But if there is not particularly sensitive data, then there isn't a requirement. So there isn't absolute clarity as to whether or not you should carry out one of these things. But certainly if you fall into any of the buckets that are mentioned in that particular part of the legislation, then you really need to carry one of these out. And many organizations don't know how to do that. It's interesting again that in the UK, the Information Commissioner's Office has a very good website, and it has some very good advice on how to do DPIAs. So there are things that you can find that exist today that are useful and relevant, because under the current legislation, you could well have been necessary for you to do this. One of the key differences that I just gave an example of earlier on is that it applies both to controllers and processors, and it is not just limited to where the controller or the processor is located. It is concerned with the data that is being held. If this data relates to anyone who is in the EU, then it is relevant to them. And this has got the interest of the big American companies that hold and process data. So from the perspective of data processors, as opposed to the data controller, it means that they actually have a statutory obligation to protect the data. They have a statutory obligation to communicate breaches, and there are also a series of extensive requirements that they have to comply with in contracts that they offer. So they can't wriggle out of it by saying, hey, you know, it's all your liability. You may, in fact, need to appoint a data protection officer if you are an organization that is larger than 250 people and various other things. So you don't, if you're a small organization, you don't necessarily have to have one. Most large organizations will have to have one, but they don't need to be part of an employee. You can actually outsource the DPO. And they need to know what they're talking about, is what that is basically saying. So this is what has got everybody's attention, which is these two levels of fines, up to 2% of annual worldwide turnover, if you just sort of commit a venial sin, whereas it could be up to 4% of worldwide turnover if you are clearly recklessly negligent. Now, until the first people are fined, we won't really know what that actually means. And the definitions of where you are on those various things remain to be clarified. But that is basically the outline of the legislation. So what everybody needs is to have an action plan. And we've identified 6 actions that everybody should take. One is they should discover the personal data that they hold. The next thing is that they need to have a clear set of processes for managing consent, because when you look at what consent means, it is consent. It's a positive, affirmative consent statement per purpose, per piece of information. And that's quite a rigorous requirement No longer is it acceptable to have one tick box to cover a 14,000 word list of things of what you might do with it. You have to have control, and largely speaking, the security technologies that we have are good for dealing with control of access to data, but you have also kinds of things like control of aggregation. How do you deal with building up the data? How do you deal with subject access requests and things like the right to be forgotten? And the burden of proof in all of this lies with the processor and with the controller, not with the data subject. The next thing that you should consider is what happens if you're going to use a cloud. Is your cloud provider actually going to enhance or reduce your compliance with this? And how do you control what PII there is in the cloud? And what does certification of cloud providers mean? Because suddenly we've got all of these cloud providers saying they're ISO 27018 certified or whatever. Does it actually mean anything? We need to have the data protection officers, as I described. And one of the biggest things is actually preparing for a data breach. You know, there was this Cisco chairman who a couple of years ago said, it's not a question, there are two kinds of companies. Companies that have been who've had a data breach, and companies that know they've had a data breach. So you have to assume that you're going to have a data breach, and you have to have a plan to prepare for it, and a plan to communicate. And you need to have that figured out in advance, and there are plenty of examples of what happens when organizations don't have that kind of plan. So, in summary, the GDPR is going to change the way that businesses do business in Europe, and they need to prepare. And basically, if you prepare, you know, it's the 5 Ps, proper planning will prevent pain and payment. So, with that, I'm going to, I think I've more or less on time, I'm going to hand over to the next speaker.
Can I ask a question?
Yes, you can ask a question.
So Mike, thank you very much for explaining all of this. Now, as you explained at the beginning of your talk, GDPR is quite an interesting topic over the past months, and everybody's talking about it. I was involved in a workshop last August or September in Brussels, and we were talking about GDPR compliance with lawyers. Now, you told us you're not a lawyer, you're looking this from the IT perspective, and we talked about GDPR compliance. Now, the question I have is, how does an organization, small or large, actually show that it's GDPR compliant for their data processing activities? Is it just a piece of paper that says you're compliant, or do you need to show in-depth proof that you are actually compliant? With the lawyers, we had an extensive discussion, and, well, at least to me, I'm not a lawyer as well, nobody understood what they said, but maybe you can give your perspectives, if you will, on this.
Well, and that was one of the kind of factors that I was trying to allude to throughout this, which is that until many of the details have been clarified, we won't actually really know what compliance means. You know, what is good enough in terms of the security provisions you've put in place? You know, when should you conduct a DPIA? You know, is your data protection officer up to it? So the answer to this is there is no kite mark for compliance. There is no normative standard that you can turn to and say, I've done this. What you're going to have to rely on is your lawyers and your consultants to be able to argue in court to prove that you've done what was necessary. So from the IT perspective, the best advice that I can give to people is to look for the best current standards that exist and for you to make sure that where they are normative standards, you have certificates for things like ISO 27001. Where they are not normative standards, that you are able to have independent audit assessments that say that you've done what is the best practice according to these things. So, for example, if you're a cloud provider, it's ISO 27018. Now, some of the standards that OASIS is coming out with are going to fit into that bucket. And so being able to say that there is a standard and that you are, to the best of your ability, complying with those standards is probably the best defense that you could have. But you also need to be able to show proof not only that you are complying at a high level, but that in a specific and particular instance that you can trace where the consent was given, that the data was in fact collected for the legitimate purpose, that it was then only processed in that way, and all of those other things that I've described. And that takes you back to looking at your data processing systems, your security systems, and your logging and auditing that's going on there. And perhaps if people even are going to dive more deeply into that, the fact that the systems themselves were engineered, as John was saying, to meet those things. So I don't know whether that's an answer that helps, but...
Yes, thank you.
All right. So I think it's over to the next speaker now. Yes, okay. Thank you very much, everyone.